up there. That's the,
Yeah.
it's 2 days ago.
Does that mean you'd like to start? Is that what that means?
Does that mean?
Actually, this says 5:59 right here.
Is that the
I
voting?
don't see, do these work anyways?
No, they're not.
I didn't think
They're
so.
not recorded. They're just plugged in for power.
All right, 6 o'clock. This is a meeting of the Board of Selectmen, Town of Avon, a workshop meeting. We have a special guest speaker to give us some information tonight. And why don't you introduce yourself
Sure,
and then you can educate us.
sure. Thank you so much for having me. I'm Kate Federoff. I work for a law firm, Mead, Telemann and Costa, and we do municipal law, clearly. And I am the person in the firm. Among some of my other responsibilities, I handle all of our host community agreement negotiations with marijuana establishments, whether or not they be medical or recreational, so adult use. And tonight we are going to discuss more broadly what can and cannot go into an HCA. So as for folks at home who may be watching, there's a medical marijuana dispensary that is looking to site in Avon. So the idea of this meeting is to say, Board of Selectmen, this is what you can and can't ask for in your HCA. If you so choose to enter into the HCA with that entity. So before we begin with the HCA itself, probably makes sense because this is new to Avon to kind of talk about the legislation and how we got here. Specifically in 2012, there was a ballot initiative. So residents from across the state organized to put a ballot question on the election ballot, and medical marijuana was legalized. That all fell under the umbrella of Department of Public Health, and they promulgated regulations, etc. The landscape sort of changed, even for medical marijuana, when recreational or adult use marijuana was passed in 2016. And following that ballot initiative, they created a comprehensive legislation to deal with recreational marijuana. Nestled in that legislation was a requirement relative to medical marijuana, and that was that you have to have a host community agreement. So before, it was a little bit like the Wild West. People were executing host community agreements, but there really wasn't a framework, and it was just some person who thought it would be a good idea to kind of carve out specifically payments and responsibilities. But instead it became law through the course of the recreational marijuana legislation. So we have that requirement now. You need an active HCA in order to cite, but also to continue operations. So it's a really good tool for communities to, number one, describe to the company what its requirements are and conditions, and it sets the framework for what your community would embrace and what it wouldn't. And it's an important tool for enforcement too, because absent the HCA, or if the HCA gets revoked for non-compliance issues, etc., you have an enforcement issue because they technically will not be able to operate in the town anymore. And that gets reported to the CCC, etc. The CCC being Cannabis Control Commission. So that's sort of the backdrop for why we're talking about negotiating an HCA. Then the second piece is what goes into an HCA. And there are a whole host of things that go into an HCA. So the law is pretty generic. It says you shall set forth all the terms and conditions that you're imposing on the company in terms of operation. It allows you, it's not mandatory, but it allows you to collect a community impact fee. And what's the other thing? Oh, and of course, the responsibilities of the company. So those are the general pieces of the legislation that are required to go into the host community agreement. But that really doesn't say much. So we can talk about what typically goes into the agreements. And the first thing, and one of the most important things to the community is what is the community impact fee? So there are restrictions on the community impact fee. The legislation gives a maximum amount of 3%. That 3%, whatever you collect in revenue, so if it's $1 million gross revenue establishment and you get 3% of that would be $30,000, thank you. You get
She's a
30.
lawyer, not an accountant.
Exactly, I was like counting on my fingers. $30,000, those fees are to be used and directly connected to what the impacts of that business are on the town specific, right? And so under the law, and this is established through case law, mostly through permitting, it has to be a unique cost, right? Because every business imposes a cost on the town, right? There are roads that are used because you go to the Walmart down the street, or you go to the Target in the industrial park. Those roads get driven over and have to be replaced, et cetera. That's not unique. So these have to be unique impacts to the town. So oftentimes what we see is what are the impacts that are different because it's this different product, police, fire, so the EMS often on fire, education programs, so perhaps your board of health may have some inspection requirements. So those things set that kind of industry apart, and that's what allows you to impose the community impact fee. So again, excess of, it can't be exceeding 3%, it's got to be reasonably related, and what the law says is it can't be effective for longer than 5 years. So you've got a max of 5 years on this fee. Now, what we write in our agreements is we say at the end of the 5 years, we'll renegotiate. And if it's allowable by law, then we'll renegotiate the fee. And that piece is unclear because this community impact fee is something that's the subject of many, many bills up at the legislature. Which there are people on one side of the fence that say we want to eliminate the community impact fees generally because we want to normalize this. We're not doing anything different than any other business, a liquor store or whatever. So they make that kind of policy arguments. And the municipalities often are saying, listen, we've allowed you to come into my community, and other communities have opted to shy away from that kind of business. And we have these costs that we're anticipating. So as the exchange for allowing you to operate here and and causing us to have these costs, you're going to have to subsidize some of that, right? So we don't know exactly how the legislature is going to react to those bills. Again, there's a committee that's been put together. Everyone's analyzing it, and there are lobbyists on both sides. But that's the background there. The other thing is through guidance. So the Department of Local Services, the municipal branch of the Department of Revenue, has given us some guidance as to where does that community impact fee go. So once you collect that fee, it goes into the general fund, unless the town meeting in towns and cities, it's different, but town meeting makes the decision to dedicate either a portion of those funds or all of those funds to a specific purpose. So you can put it into the stabilization account or some other account. So that's one thing. It goes into the general fund of funds. The other thing is they say that, and this happened before the legislation on recreational marijuana came out, you can't extract gifts or donations, but if you do, it's to count towards your 3% max cap, right? So what you saw oftentimes in the old host community agreements were donations to, say, the senior center, because, for example, seniors may have glaucoma or sleep issues or some other things that you may benefit from marijuana, and they would be your customers. So give a donation to the senior center, or give a donation to the Little League, because it's the kids who are fearful that are going to improperly get marijuana. Now, if you make those donations have to be counted toward your 3% max cap, because otherwise what they say is it's an exaction. It's not voluntarily given when it's a requirement of an agreement, right? So they put the kibosh on that. So that's the deal with what the community impact fee is, and what the limits of the community impact fee are. Another thing that we see in the agreements are, when do you pay the community impact fees, right? So in every agreement that I've written, and I think every agreement that I've seen, you wait to start until they start obviously generating revenue. So after they open the doors, and then the 5 years starts ticking then. You can pay it quarterly, you can pay it annually. All the timing is spelled out in the agreement depending upon your wants and needs. There's possibility of payment penalty, just like any other bill. If you don't pay your water and sewer bill, you get a penalty. Same thing here. Another thing, which I think is a good enforcement tool that I put in my agreements, is there's a provision that already exists in law. It's in chapter 40, section 57, and it's for non-payment of taxes. And what that statute says is that if you fail to pay your taxes or other municipal charges, then your permits can be revoked. There's a hearing process, due process requirement, et cetera, but your permits can be revoked. So what I say is, because the statute not so clear as to what other municipal charges are, I spell it out right in the agreement. The parties agree this is an other municipal charge, and that allows us to pull, for example, special permit or revoke the agreement. Of course, we could do that anyway, but it allows us to pull the permit. If you have some towns adopted a bylaw to create a licensure structure, like a liquor license structure would be, you would be able to pull that license if they fail to pay the community impact fees. So that's another option that you have. It talks about set-offs. So for example, there are some towns that say, listen, I have this anticipated cost, but I'm going to have to front the money for the cost. So I'm going to ask you to front the money for your community impact payment. So it might be $5,000 or $10,000 because you need a crosswalk or whatever it is that you need. You front that money and then it's offset against the 3%. So those are some options. It talks about what happens if you relocate. We're not going to pay you back for funds that you've already submitted. I mean, that's kind of already built into the pie because it's based on revenue they've already generated, but regardless. Another important thing is I put in there specifically because depending upon how you budget, some of these unique costs that you're absorbing with this company might be built into your budgets automatically, right? So if you have 5 police officers and you pay them X amount, you're not going to carve out for every time they have to report or respond to a marijuana facility. You're not going to be able to quantify that so easily. So what I put into the agreements is a waiver, in that the parties to this agreement, specifically the company who's contracting with us, waives any claim to challenge whether or not the 3% is reasonable, because they acknowledge that the costs imposed upon the community are actual costs, even though they might be built into the pie and you haven't carved them out in a separate document. And that's really important because recently in Haverhill, city of Haverhill, got a challenge in Superior Court. And the person challenging was the company that cited in the city. And what they said was, we don't believe that we're costing you this much money and we're taking you to court saying that this provision is illegal. For me, we're all going in eyes wide open. We negotiate an agreement in good faith. So I build that right into the agreement that they acknowledge and understand that they're going to cost the town of Avon a certain amount of money, and that amount is 3% or whatever it is we settle on a community impact fee, such that they can't go back and challenge us in court. If some other Cannabis Control Commission or the Attorney General or someone else decides to do a global approach and say, I'm going to look, and that's different. But here, the parties who are working and negotiating the agreement together acknowledge and understand what these costs are, and they waive that. So another thing I build into my agreements is just simply, I'm not going to challenge the connection fee, for example, for water. I'm not going to challenge my water and sewer rate, provided you're not doing something strange and like charging up or something like that. I'm not going to challenge my real estate taxes unless it's a matter of routine assessment, but I'm not going to, for example, claim a nonprofit status and then not be subject to taxes. I'm going to waive all that stuff. And so I build that right into the agreement, and I think it's a smart thing to do. Another thing, depending upon what your wants or needs are, you can talk to them about operations. So for a retail facility, the impacts generally surround traffic, right? For a cultivation facility or sometimes a manufacturing facility, you're worried about odor and noise. So you can build into the agreement, for example, a requirement that they do a traffic study and pay the peer review. So in your regular permitting process, you have a big project come in, say a big mega store comes in, you have a process, it gets peer reviewed. So another engineer looks at the engineering that's submitted by the company to say, this is all set. I agree with his or her findings, and you should feel comfortable with this project. So I build that right into the agreement. Now, because Avon has a special permit granting authority, you have a bylaw which regulates this use. What I like to do, because you don't want to have two traffic studies, and especially you don't want competing results. I acknowledge that if the planning board or the zoning board, I think it's the planning board here who's the granting authority, if they require it, you agree you're going to not challenge that requirement and say it's unnecessary or something like that. Now, I have other communities where they haven't regulated marijuana at all. So they have it just falls into, retailers would fall into commercial, cultivation would likely fall into industrial. But they don't have a special permit process. So they wouldn't necessarily get that review. It's a use as of right. So in those circumstances, sometimes you might want to build in design criteria. What does the building look like? If it's downtown, in the square next to St. Michael's Church, you might want it to look different than if it's up in the industrial park. So you can build in those kinds of things, especially where you don't have a permitting process. Another thing now operators sometimes want to impose conditions on you. So I've seen operators impose buffer zones. So I'm going to invest a lot in this town, and I don't want the situation that someone is going to site the same facility and eat up all my clients right next door. So I'm going to require that you will agree not to execute an HCA with another company within a certain vicinity. So they can put in protections and request those things as well. Or I've seen companies try to say, if you give a better deal to someone else, the second guy who comes in, say you impose 3% on me and you only impose 2% on them, I get the same deal. That's an option that they could try to impose. Another thing, and this is generally in all kinds of contracts, this one is not any different. What's the term? And how do we terminate? So the term here would be 5 years. And because, as we talked about earlier, the payments don't start from the day you execute the agreement, which is not as typical as other contracts that you see. The payment provisions will continue on until that 5th year payment is made, despite the fact that it might be beyond the term. So that survives. And then how to terminate, right? It's breach, it's failure to pay, it's failure to meet any of the conditions that we set out in this agreement. Same thing as a normal contract that gives an opportunity to cure. So you say, hey, you didn't give the community impact fee and it was due last week, gives them time to correct that. It could have been an accounting error, whatever. If they correct it, then no harm, no foul. We're not going to terminate. If they don't correct it, go ahead and terminate that. And that business has to shut down. Community support. This is a really common provision. One thing we like to see, and one thing that's attractive about marijuana establishments, is they're going to get their workforce from the town of Avon to the extent they can. So it's a local hiring preference. Now, there may be some positions that you would need a specific expertise and you might not have that type of person in Avon, can't comply, but they have to make a good faith attempt to draw from Avon in order to employ our residents, which is great for economic development. Another thing that is important for community support is volunteer hours. And a lot of these companies will donate volunteer hours of their employees, and they'll do things. Sometimes it's education and outreach. Maybe they go to the schools, or maybe they work with the school resource officer to build a more robust program for drug awareness, for example. Or I have a company that said they might pick up trash on the highway, which would be great too. So it's all to become part of the fabric of the community and really be a partner in a way that's beneficial to both parties, because they're invested and you're invested in them. So it's an interesting way to work with a business that's really unique to this industry, because we have this HCA requirement that can get these companies more woven into the fabric of the community. You know, other things, town obligations. We're going to support your application to the CCC by signing and agreeing to execute this form that says, yeah, we've got an HCA with these guys. Yes, they're cited in an area of town that's zoned for marijuana establishments. Yes, they do have to go through that whole permit process and they haven't done it. And we're going to retain jurisdiction and authority over that permitting process. We're not going to say zoning board or planning board, you have to do X, Y, Z. You can't do that. You can't usurp their authority. But we, as the executive body, is going to support it. Another thing, and for folks at home, the biggest concern for marijuana enterprises is security. So there's a requirement in there that says they have to submit a comprehensive security plan to typically the police chief or someone in the police department who has expertise in that area to say, does this work for you? Or are there anything, any unique things about this town that we have to know about so we can craft our security to address that? So that's really important. There are reporting requirements. If there is an incident, say a truck breaks down on Harrison Boulevard and someone happens to break in, there are reporting requirements. There are reporting requirements if you break into the store. So you can't hush up a crime in order to fly under the radar. It's all very open. In terms of security too, there's really robust regulation on the state side. So the CCC requires what's called seed to sale tracking. So from the moment that seed is born or whatever happens to a seed, however they're created, till it becomes a little plant and grows beyond that, and it turns into marijuana flowers. The flowers are converted to oils or sold as the flower and chopped up or whatever, however they distribute it. And, or if it's put into another product like a chocolate bar, all of those steps are marked from that seed. So if you have 20 seeds, you have 20 registers following that guy all the way up until he's into someone's belly or lungs or whatever it is, wherever he's going. So it's very secure, and they have a lot of mechanisms to ensure that if something were to happen, everyone knows, and they're out there trying to figure out, how are we going to recover that marijuana? Who are we going to prosecute? All of those things. So in that way, it's actually really positive because there's so much control. Another thing on preventing diversion is you have to have someone on file as who to contact. If there's a fire, we need to let the fire department, the fire department number one knows where they're going, but they need to call up and say, okay, there's a fire in this part of the place. I don't want all that marijuana going up. So, you know, there's someone to call so they can report back and help everybody coordinate a response.
Visual, great. Yeah. Sorry.
I think I saw a movie on that.
There's one sentence.
So there's a lot of security measures that are built right into the agreement to ensure that they're responsible, that they're not going to do something that would hurt the residents of the town. Again, we talked about design. You can impose some design standards in there. Since there is a permitting process, I might be reluctant to do it because really what you don't want to have happen is conflicting requirements. So you may say, one of the things I like to put in, like to be look and feel of the area, you know, that kind of stuff. It's a little bit more generic, and then allow those design experts in the boards that you appoint or get elected. And then what we talked about is limitations of operation. So what we don't want, Avon's a no community on recreational marijuana. We don't want this to be, am I going to modify this agreement to create a adult use marijuana store? No, you can't. Not by changing any of the terms of the agreement. And here, it spells out specifically. This agreement is only for the use of a medical marijuana dispensary. No other use is permitted. So it doesn't allow for any modification, and everyone understands that from the outset, which is important because there may be legislative changes that come into being, but we've already privately contracted. With one another to say, no, this is what we're going to do. And more importantly, then it says also no consumption on premises, because we don't want that to happen. That would be against the law regardless, but we spell it out. That's not allowable. It's not to be tolerated by anyone, whether it be staff or customers or patients. Not allowed, not in the back room, not in front. So we talk about closure, because what happens if this company goes belly up and you've got, I don't know, 60 pounds of marijuana hanging out in a building and you don't know what to do with it. So what we say for closure is the CCC already requires a bond for closure and cleanup. And we say we want to be a party to that bond too. So like you do on a construction project, we want to be able to pull the strings if need be. What if the CCC is overwhelmed by closures because there's a collapse in the market? They can't get to pulling all these bonds and forcing these closures. This gives us the right to step in their shoes, force the issue, collect on the bond, do the closure ourselves. Get rid of that marijuana. hopefully not Cheech and Chong style. To Greg's point
Donate
earlier.
to Council on Aging.
Donate to the council.
So.
Avon will become very popular.
Right, and then finally, there's your boilerplate contract stuff, I don't waive any rights under this contract because I didn't act on something. If something's determined to be illegal, doesn't mean the whole contract's thrown out. You're still obliged to provide, comply with all the other pieces. Those kinds of generic boilerplate contract stuff that could be in 8-point font if you wanted to, because nobody reads them. So that's really the nuts and bolts of it. And I guess the question is, do you have any questions or thoughts or ideas yourself?
So you had mentioned that the HCA, you don't want to put things in there that are going to possibly conflict with the board's decision later on. Because I'm assuming the HCA has to be agreed upon and signed prior to any other steps being taken.
Yes.
Okay, so can the HCA be added to kind of like a lease? So say the planning board comes up with a decision,
Yep.
can we attach that to the HCA as an addendum? So that way there, it's all there, and it's, everybody can keep an eye on it and make sure they're doing it, because I've always seen in the past where sometimes boards will come up with a decision, the town will do the higher process, like the permit, the real permits and everything
Yeah.
else. But there's that gap to where the
Like a gap in communication.
well, gap in communication and what's Bob considered? The, no, but for the planning board, was the enforcement officer.
Oh,
There's that gap in enforcement. I've learned it from being on planning board. I've learned it from being on this board. So I'm just trying to look at a process to where we can take what another elected or appointed board has done and kind of keep it so that way there, everybody's paying attention to it, rather than, okay, they made a decision, we made a decision, and they're operating.
yeah, so you could say, essentially, the provision would be something along the lines of any permit, special permit, whatever, all of those conditions are incorporated here by reference. And so you reference that document, and then you could theoretically be an enforcement person under under a contract. So it would be a breach of contract. So you wouldn't go in, you wouldn't have the same ability to enforce through the building commissioner. He would have that independent authority himself. But say he, I don't know, was laid up or in Hawaii, I don't know where he is. You could come in and say, you've breached your contract because we've incorporated all of those decisions into the agreement. So theoretically, that's possible. That's a great idea.
Couple of questions.
On the,
Go ahead, sorry.
you had said that the CCC or the Attorney General's office, or actually, no, my question was, you had made mention, can the CCC or the AG's office change anything that we have already signed and decided on? Or are, once it's signed and once it's in place, is it grandfathered in? Say legislation changes,
Yeah,
can they go back and say, oh yeah, you're all set, you don't have to do that, and we're like, no, we have a written agreement. Do they have to follow our written agreement until the 5 years is up?
so that's the piece that's unknown, right? And that really depends upon the legislation. And to be clear, the state of the law is such that the CCC doesn't have any authority or oversight of these HCA's. And the AG, you probably read about it in the Globe when the AG issued all these grand jury subpoenas for your notes and for your agreements and draft agreements, et cetera. The AG, in that instance, because it was a grand jury subpoena, said to us, okay, this is criminal, not civil. So they, in my estimation, they didn't tell me because I'm not one of them, but in my estimation, they were looking for criminal activity similar to what happened in Fall River or New Bedford, Fall River. So yeah, they were looking for Jaziel imitators, and where he was criminal because he was putting it right into his pocket as opposed to. Did I not comply with, for example, some other communities may have had 3% and a donation to the Council on Aging. That wasn't personal benefit to them, which would have been criminal, but it may not have been compliant. So they weren't looking for civil infractions, in my estimation, they were looking for criminal infractions. So they also wouldn't have oversight of this in a way that I can think, to be honest. But the question is, will the legislation change? And that I can't answer for you. There's a possibility that they could reach in and say, no, we're going to invalidate all of these agreements. That does exist.
I have one more. Sorry.
Can I follow up on that one?
Oh, yeah.
So just, for clarification, so his question, so if there's a piece, an article of the agreement, the HCA, but then there's some case that changes or clarifies case law and says that that's not, I'll use the term legal, but maybe some other words. So I think your question is, if we have an agreement prior to that case law, does our agreement supersede the case law in the future, or does case law then revert back and says anyone that had this says you can't sell it on Tuesdays, and they say, well, that's illegal, and we say, no, you can't sell on Tuesday. Right, is that kind of what
Yep.
you're asking?
Well, similar, it's kind of a two-part, yes, something like that, and then second, the agreement that we make, the friendly agreement that we make, can they come back and say, okay, we're 3 years into it, and they came back and said, you know what, we realize that, like you said, that left side of the room wants to go and say, well, you know what, this really is no different than any other business, so why is there an impact agreement to begin with? So halfway through our 3rd year, can they go back and say, you know what, forget it, you're all done, no more money for you, and they don't have to follow the agreement, they're just regular business.
Depending upon what the legislation says, it could happen. I'm not saying that it couldn't, because it could. So that's why you have one of your boilerplate contract provisions, severability. If a provision is determined to be illegal, and that could be determined by legislation or by get sued or whatever, brought into enforcement if the CCC decides to take auditing authority over these HCAs, so they strike it. The other provisions stay in effect. There's another provision in there that says if that provision is so fundamental to the agreement, the parties have to work together to negotiate a resolution. And maybe that resolution is to say, we have to part ways. That could be a possibility. I don't know exactly. It depends how you write that provision in your agreement, but there is that risk. I won't tell you there's not that risk. There is a possibility that folks would be grandfathered, and then it's a matter of enforcement. Who has enforcement authority? How are these agreements brought to their attention, et cetera, et cetera, et cetera.
And then the last question is, the CCC is the one who governs all of these businesses. So with that being said, if there's, I'm hoping and guessing that they police what they do and go out and make sure that these places are following the rules and everything like that. Do we, as the permit granting authority, I guess, because that's basically what we're doing,
Mm-hmm.
do we get reports or do we get notified of it? Because I know in other aspects of it, things that happen in town with other businesses that we permit, we don't hear about it until 6 months down the road.
Yeah, so
And to me, I don't agree with that, because there could be a couple of infractions that are taking place. We don't know about it. Their license would be coming up. We're renewing their license thinking that they're the greatest thing since sliced bread, and they're breaking all the rules in the book, and we don't know. So do we get notified, or are there monthly, quarterly, biannually reports that get sent to us on the businesses that we have in town that provide this type of service or product?
yeah, there are reporting requirements that are built right into the regulations. And certain things are required to be reported to the police department. And on top of that, that's typically built into the host community agreement as well, so repeated. Some of the stuff is already built into law, but why not put it into the agreement and make it super clear? We expect this. And in that paragraph, you can put any enforcement actions taken by the CCC, whether it be from letter of warning to cessation of service. So you can build those right into the agreement.
Can I follow up on that?
Yep.
So the CCC, how many members and how many enforcement people do they have that we know of at the present time that belongs to CCC?
Yeah, so I can't tell you that exact number, but let's just say, like many state agencies, they're not as fully staffed as they'd like to be.
And how many, do you know approximately how many businesses are in operation both on the adult side and the medical side at the present time
Oh, good grief.
that the CCC technically oversees?
And
Many. So it's like a lot of other things that it's nice to say that we're going to get a report on a regular basis or whatever, but chances are they're probably only going to do enforcement when there's a complaint.
yeah,
And you may not know about the complaints, I use that term loosely at the
Yeah.
moment. Even though they may come out and let's just hypothetically say that they're accused of selling to non-medical people.
yeah,
So they might come out and then they might be in a 6-month investigation going on because they may not find an infraction right away, but we may never know during the investigation
yeah.
that that's going on until after. And if they don't find anything, we may never know that they were investigating. Is that a possibility? I'm not trying to.
It should, and anything can fall through the cracks. I mean, you guys, well, people would know that. I'm sure you've seen it happen, right? I mean, everyone goes into things with best intentions, and then when something happens, you said, how did we not foresee this? So, but you can, for example, in your agreements, require quarterly meetings with the police department. Let's talk about how things are going. This is what we're hearing on the street. What are you doing? So you can build in those kinds of making sure that everyone's behaving provisions in the agreement. So, and I don't want to say that there's no risk, because there's a risk with every kind of business, you know, and it could be from your local little market, little convenience store, hold up to a liquor store break-in, to marijuana break-in. Yeah, I mean, it's possible, right? And nothing is Fort Knox, but these things are very heavily regulated. And to your point, and I don't know exactly how the CCC finds stuff out. I'll tell you an interesting thing, and I actually couldn't believe it myself, because I was more of the opinion that you have, like, how are they ever going to find this out? One company that I know of was reported because they had done a sanitary inspection. I guess that must have been how they discovered it. But they were doing a sanitary inspection, and they had like a birthday cake in the freezer, and it was in a freezer. I don't know if they put the marijuana in the freezer, because we marijuana freezer, and they had a birthday cake in there, and they got shut down right away. So that was up in the 495 belt. And so they are, I think, pretty cognizant of the fact that folks are concerned, and they want to ensure that they're meeting all the residents' expectations in terms of enforcement. So.
Mr. Eric?
Just for the knowledge, anyway, it's according to this, there's 15 inspectors for the CCC. Yeah, statewide.
Yeah.
But how many facilities are they trying to look at?
That I couldn't find. It does say retail shops, grow facilities, manufacturing plants, independent labs. So I mean,
That's a lot.
yeah.
It's
I mean,
a
that
lot.
is- I guess,
And medical has been in play since, I think the first dispensaries, they were kind of slow to roll it out, but I think they started coming out in 2014. So it's 2021. I don't know.
which actually is a good segue into my question.
Oh,
The 5-year agreement,
yeah.
it sounds like there have been some 5-year agreements that have already expired.
Mhm.
And have those been successfully renegotiated with the municipalities that we know of?
So I have not yet renegotiated a new agreement. I'm still in the middle of my agreements, to be honest. I am not aware of one that has been renewed, but I would take a hazard to guess that the community impact fees are in those for another 5-year term. It hasn't been challenged in court, that's for sure. I expected to see case law on that since this happened. 2016 legislation, 2018, we're 3 years, well, we're 3 years in, right? So, but I expect to see some challenges there to say, hey, there's a 5-year limit on this and the town wants us to re-up and we're not willing. I expect other companies, especially some bigger companies that are making really significant amount of money, and I know there are many of them, don't care. That's all in the rounding for them, to be
Just a
honest.
write-off.
I mean, that's weird to say, but because it's a big
No,
chunk of
it's
change for the
playing nice.
municipalities,
Yeah.
yeah.
Okay, and with the 5-year time clock on it. So if I'm understanding it right, if we were to sign an HCA,
Mhm,
let's say for argument's sake, it's on January 1st,
mhm.
they don't open until September. Now you would say the 5-year ticks from the time that they open, not the time that we sign the agreement.
Yeah,
So
the
would we have to
payments.
do then an addendum down the road to the HCA so we know what date that's started on?
No, so they'll just notify you and you'll know because you either get your quarterly or annual payments and someone's going to have to keep track and say, gotten that payment, but regardless, remember, so it happens more often with like grow facilities because it takes a while for those guys to build out. But in the beginning to retail, even the permitting process to the CCC was pretty tough. So they seem to be going more quickly now. But let's just say it's a year gap. Remember, at the end of year 4, from when you signed it, they're going to want to enter into negotiations or maybe 6 months before it expires for a new HCA, because even if they have to continue payments to you, they can't operate without the HCA. So they need that thing for operating. So they're going to renegotiate. But if they don't, if they decide, you know what, we're going to end here, it allows you to collect beyond the time, say they close their doors, but they closed, I don't know, the 29th of June instead of June 30th. And it takes them a while to close their books and you're still owed a quarter's payment. You're going to get the payment even though the agreement's technically terminated. So that's
So,
the idea
okay.
there.
So the payments actually continue on from the 5 years at the time of the opening of the business.
Mhm.
So if there's a 1-year delay between signing the agreement and the opening of the business,
Yep,
even though the 5-year, January 1st, 2022, let's say, goes to January 1st, 2027,
yep,
it could conceivably go to January 1st, 2028.
yes, conceivably. You will have an interim HCA that's going to cover the next 5-year period, but that won't eliminate your additional year, right? Because that's the
Right.
concern, that you're not going to get the full 5 years. So you'll still, for the payment purposes, be operating under the old agreement, and they're going to overlap with the new agreement.
And the only other question I have is the contributions or donations, or whatever way you want to say it, to other town departments, groups, civic groups, whatever. You had said that money is part of the 3%.
if it's per the agreement. Now, what
Well,
they
okay.
want to do voluntarily is different.
Well, that's what I'm asking. So if can they voluntarily say, we're gonna give $20,000 to the senior center, we're not gonna give you your 20,000 this quarter? I mean,
Yeah.
is it arbitrary, or do they need an approval from the licensing board?
No,
to do
just
that?
like anyone can, I can cut a check to your senior center.
But
and
I'm saying if they're gonna say it's part of the 3%.
Oh, no, that wouldn't be part of your, because you haven't required it, so
Right.
that wouldn't be part of your 3%. If they want to do that for whether it be tax purposes or more importantly to them, they have this requirement to be, I forget what it's called. It's like community,
It's like goodwill type thing.
Right.
yeah, it's a goodwill type thing.
But
and
if
they've
we
got-
put it on agreement that you will make it 20,000, then that is
That
part of
gets
the 3%.
Right, yeah, if we mandate it.
Exactly,
Right.
but I know, for example, there's a company that was trying to do this it's like positive community impact or something like that. I forget what it's called, and they're required to do that outside of the HCA. And some of them do things like, I don't know, more proactive, like tangible stuff, like I'm gonna give a basketball court to whatever. Some of them just look for local nonprofits like a food pantry. And they say, I'm gonna cut you a check and I'm gonna put you, but in exchange, it could be, Salvation Army or something like that. But in exchange, I'm gonna write that down, that I put that as positive community impact. And it helps them through that permitting process because they need a plan to present to the CCC. So sometimes they dump money into local community nonprofits to achieve that. Other times they do other things to, whether it be hiring disproportionately impacted people and stuff like that.
Is there any possibility of I wouldn't imagine that a recreational place would do this, but a medical place ever becoming or applying to be a nonprofit? For the purpose of the medical versus the recreational, we all know the difference
Yeah,
in profits there. Is there a possibility that somebody's not doing so well
they could be
and
a
they turn around
non,
and decide to be a nonprofit? How does that affect?
it doesn't affect the community impact payment. That gets paid regardless of whether or not there are nonprofit medical facilities. And as a matter of sheer fact, in the beginning, you had to be a nonprofit in order to qualify. They recently changed that, and you can be an LLC or other corporate form. But that doesn't change the requirement that they have to pay the community impact fee to you. And one of the things I read in the agreement, and it's important less over the lease, but if you own the property, that they're not going to claim nonprofit exemption
Right.
on local real estate taxes. So you'll get the full benefit of that piece.
So. I'm all set. Thank you, sir.
Sure.
I'll think of more as we talk.
Only twice.
One question, Steve.
I haven't asked my questions yet.
Oh, I'm sorry.
I did. Oh,
I apologize.
So first question is, certainly we hear estimates of sales and potential taxes to the town based on the 3% and so forth. Is there any mechanism in place to help to make sure that the estimates aren't overly blown to gather public support?
So, what I expect of these companies that are coming in and doing this is they have an established business plan. And what you don't like to see, and I've had this happen before, is someone, I'll give you a concrete example. Someone came in and said, delivery is the new thing, right? Everyone wants to get into delivery. This is on the adult use side. I'm going to be a delivery operator, or maybe I'm going to be a delivery courier. I'm not sure. And I'm going to have this. There was a company that had gone before them and they said, I'm going to have an exclusive partnership with these guys to deliver their marijuana. And those guys were like, wait, what? So they were clearly not prepared, right? And they were trying to ride that wave of I think there's a lot of money in marijuana and I want in, even though I haven't done any homework. So the only thing I could say is, do you have a clear business plan? I suppose you could ask for whether or not they have sufficient financial backing. All of that stuff gets vetted with the CCC. But you can tell right away if it's a business that's a sophisticated business, or if it's someone that's just trying to capitalize on this new market. And you get the feeling that they're gonna crash and burn because all of this the permitting loan is super expensive. I mean, but are there guarantees? No, like anyone else, it could be, what's this guy, Bezos, and I'm gonna sell books online, and then it turns into Amazon, or it could be that other guy who we don't know what his name is, who had a great idea and it collapsed. So I don't know if there are guarantees.
I don't know if you answer my question, I'm not trying. So if someone comes in and says, I expect to do $50 in sales a year, you're gonna get 3% of that, but they only do $5 in sales.
Yeah.
But because they put the carrot out there that the potential 3% to the town was worth money, but it's not generating that kind of money. But, you could gauge that there was certainly some public sentiment that was swayed in a direction because they saw a dollar sign
Yeah,
than what is actually taking place. Is there any mechanism there to I don't want to say stop it, but if someone comes in and says they're going to give us $10 and they give us $1, do we live with the $1 and we can't do anything about it then?
well, you couldn't collect beyond that, right? So if they promised you 50 and they gave you 5, but they legitimately only did whatever 97% of 50 would, whatever that calculation would be, if they only generated that amount of sales, you couldn't try to capture like a penalty or something like that to capture the lost $45. That wouldn't be allowed. Question is, could you write a provision in an agreement that said you're making a guarantee of, I don't know, $100,000, and if you don't meet it, we have the right to terminate? I suppose you could, but I don't think you would get a willing partner to sign that agreement.
Well, and again, this is hypothetical.
Right.
We're not trying to.
No, I get it.
I just get nervous when someone comes in and says, I know my business is gonna do this.
Yeah.
I won't use the word guarantee, but I believe that the town is gonna benefit by what?
Yeah,
And even though you may look at the business performer and say, well, that makes all kinds of sense. But of course, the performer is a guess. There's
Yeah.
no, right? It's a guess.
Right.
So, and I just look at a neighboring town or city, whatever you want to call it,
yeah,
that has how many in that,
Just in that one corner of the,
well, just in the whole city, which is relatively a
There's a-
mile
I got
away.
3. less
The
than-
street, yeah,
there's about
in
9 or
Brockton?
10,
Yes.
Okay,
I think they authorized maybe.
Yeah.
And there's 3 or 4 that are open now.
yeah. So my comment is, if someone comes in and they're gonna try to persuade us to be real
Yeah.
good and all, you have the potential to have all this kind of money, but the
and the
performer,
demand's not there
And the demand's not
because
there 'cause
it's
it's done-
already in Brockton.
right, so.
Yeah,
I'm just saying, do we live with that, or how do we deal with that?
yeah, I think, I mean,
Can we just do a 1 year, hypothetical, and again, I'm not, but can we just do a 1 year agreement
yeah,
and say
you don't
that,
have to do.
that
a
we'll
5
negotiate it after the first year to see how good they are?
It's true, you don't have to do a 5-year agreement. The question is, would there be buy-in just because of the upfront costs?
Right.
Yeah,
Well,
but
plus,
you
could the
could
CCC
certainly do less than 5 years.
Could the CCC have something to say about that if you only did a 1 year versus 5 years? Because that doesn't give them any kind of guarantee past the 1 year.
No, they couldn't. They just say right now, the only form you send to the CCC about the HCA is we currently have an HCA into effect. It doesn't say what the terms are. It doesn't say anything beyond that.
Is there anything from the CCC that says that this company or a company, kind of like you know, a business bureau that will say that these companies have all said they expect X million dollars and they can only make Y, but they're going to all these towns, is there any sort of complaint portion of like the CCC that would be similar to that? Which I think would be something you're looking for to say,
I don't
oh, you
think
can
so.
call up and say, yeah, this company's made,
They pulled the, like
they
that,
pulled 3 times 200.
like in the bid process. I never want to hire that construction company because they
Hey, hey,
underbid
hey,
it.
he's
Oh.
He said,
But
construction, he didn't say paving.
Look, the HCA is out there.
I didn't say those words. I
Where you
said.
live in Hanson, is that where you are? My office is close by.
But the HCA agreement would be a public document, right?
Yes, it
Because
would.
it's a contract.
Yeah,
So, I mean, if that had happened, we probably would have heard something about it by now.
yeah, I mean,
If there was
and,
another one that didn't make.
But if
And
and
there's,
I can
said,
tell you,
you know.
if it's a company that already exists, you could do a public records request for all the payments they've made for community impact payments
Okay, so,
or
yeah.
sales tax.
but there's a difference between what they say they're gonna make or bring in and what they actually do. That may not be in the post agreement though.
No.
That's not in the host agreement, which is the 3%.
So
Yeah,
let me ask you a question. Because this is a cash business, because banks, there's only a few banks in Massachusetts that are touching it at the moment. How do we verify? And I'm not saying it should be our job,
Yep,
but how does the governing bodies of Massachusetts, whether it's the CCC or Harry's Bar and Grill,
yep.
how do we verify that when Joe comes in and he says, I'm gonna do $1 million, how do we verify that if it's a cash business?
Yeah, so again, there's the seed to sale tracking, so instead of, you know, hamburgers or whatever, where you might sell 50 and only report 20. Here, you know exactly
Is
what.
that
you
what
sold.
McDonald's does?
That's why it's so big. I shouldn't use examples, it's really gonna get me in trouble. I won't say when you sell pieces of pavement. You know, all of that has to be reported because they follow it from the seed to bud, even when you terminate plants, like say there was a crop that, I don't know, whatever happened, rotted or didn't bloom or whatever, that all has to be reported, and when they get rid of the product, however they get rid of it, they have to report that too. So all of that's tracked, number one. Number two, built into the agreement, if you think something shady is going on, you have the right to investigate their books.
Yeah, I remember the agreement did have something in there about us being able to do a pseudo audit
Yeah,
to make sure they're staying on the up and up with us too.
right, exactly.
So if they're in business and they're in cash business, you are not smart enough
No.
to figure it out.
Really?
Yeah,
Yeah, I get you, yes.
yeah, but it really is tracked so heavily. I think it would be difficult to actually hide the money in that kind of a business. I think it's more the hamburger business where that's gonna happen, or
So how many of these agreements have you participated in? About, round
oh
numbers.
God, so.
150?
No, so let's see, I probably have 10 in one town. You think Brockton's got a lot. I have 10 in one town, but they're not all retailers because I've done both cultivation, retail, all that stuff. I have like 6 in another town. I have one there. I've probably done like 20 or
Okay.
so. Yeah,
So out of the 20 that you did,
maybe 30.
okay, whatever number, what is the one or two things that you found that is either the most difficult to enforce from the enforcement side, not, do you represent the other side at all, or you
No.
just strictly municipality?
Just municipalities.
Okay, so from your agreements, what is, you know, one or two things that has been difficult for the municipalities to enforce that you think needs to have more attention paid to it within the HCA than previously.
So, to be honest, in the communities where I've negotiated agreements, it has been so positive for them. They love the revenue and they've had zero incidents in terms of police response and the need for police and all of that stuff. Because once that rollout happened, I mean, remember in Leicester or wherever,
That
where it
was
was
a
like
mess.
nuts
Yeah.
for, I want to say it was like 2 months.
Yeah.
Once all of that happened, and things settled down, my communities didn't have the same traffic impact or anything like that. So I'd say we haven't had to do any enforcement, even for odor. So, for example, that's actually important. Not for you guys because this isn't cultivation, but that was a huge problem. I think it was over in Franklin where there was a super smelly grow facility. And it was so much so that I think the dog grooming agency, every dog that came out of there smelled like cannabis. And
They were all high.
I don't think they were high, they just smelled. But even the odor control for these facilities has become more sophisticated and they've adapted from West Coast to East Coast where there's more humidity and all of those things. That they're literally, I have not had a single call for enforcement, either from the Board of Health for nuisance or a police department to say we have these repeated problems with customers acting up. Nothing like that. And for the retail facilities, I have one town where they put, I think, two retailers, and it's a small town. It's not a city. They put 2 retailers and their commercial base is in their downtown. And it's like sort of a walking place. It's not a big thoroughfare. It's not even like Randolph Ave. It's a little road and they haven't had a single problem. And the idea is they're trying to attract people to their restaurants and things like that. So they're viewing it really as a economic development opportunity to draw people to their downtown, as opposed to I have other towns where they say, put that in the industrial zone and that works for them. So, but even when it's in the heart of the community, there haven't been issues that I've seen.
Have you had the opportunity to research the way that the town has voted in the 2 elections? The first one, I think you said is 2012?
Yeah,
First
for
one, right?
medical.
And then we again had the opportunity to vote again at town meeting for I guess you're calling it adult recreational usage.
Yeah,
So I know at one point there was an opportunity for the town to vote again, I think after the 2012, to vote again to either confirm the original vote or to, I don't know what the word is, but to vote, to say that the original vote they didn't want anymore, they wanted to change.
so I think I know what you're talking about, and there are 2 buckets there, so let's go to the one that I think you're talking about, and that's the adult use. And the way it worked, and stop me if I'm going off track and not understanding, but the way it worked after the 2016 election, if you were a yes community, meaning your residents voted more than 50% in favor of legalization, and that's all reported, then if you wanted to prohibit recreational marijuana in your town, there was a process to prohibit it. Whereas if you were no, and I can go through that process in a minute, but whereas if you were no community, so less than 50% of your population voted in favor of legalization, then there was a different process to prohibit. So the yes communities, the process was 2-pronged. You had to do a ballot, a town meeting vote to create a bylaw to say marijuana is prohibited in the town of Avon. And then that had to be followed by a ballot measure on your local election that said, shall the town prohibit recreational marijuana. If you were no community, all you had to do was pass a town meeting bylaw to say marijuana is prohibited in the town. So all of that changed after, and I'm forgetting the date. I want to say it was like December 2020. If you hadn't done it by a certain date, and I think it may have been December 2020, then you had to do the two-pronged approach regardless of what your original vote was. So that confirmed whether or not you wanted, forget about legalization of marijuana, because maybe you personally wanted it, but not here. That was a confirmatory requirement. On the medical side, it's different because they didn't specify that in any legislation to say this is how you prohibit it. And there were towns, I want to say it was somewhere up north. I don't know exactly what the town was, but they tried to go in and pass a bylaw that said medical marijuana facilities aren't allowed in any zone in the town of ABC. And, you know, when you do a bylaw change at town meeting, you send it off to the AG. And the AG sent them back a note and said, can't do that. And what she said was that because it was a matter of access, and if all the 51 towns in the Commonwealth, if they all passed bylaws to prohibit medical marijuana, these patients wouldn't have this resource that the Commonwealth wanted them to have. So it was sort of like adult, I don't want to liken the two, but I will. Adult entertainment or bookstores or whatever, there are certain restrictions. You can't prohibit that in town. And so what most communities do is they put it right in their industrial zone, you know, or some other place, and there are all kinds of requirements about whether or not people have access and blah. But it was like that. They said for medical marijuana, you can't be prohibitive and disallow it.
So they looked at almost like a healthcare angle rather than a retail
Yeah,
angle.
it was kind of focused on that.
Yeah.
And
We
that's
got a
still,
1 year moratorium on it.
sorry,
We got a 1 year moratorium on it. The Cole Capitalli gave us a 1 year moratorium
Yeah.
to enact bylaws on it.
exactly. And tons of communities did that because what they said was, hey, this was thrust upon us at an election. And I have a town meeting in the case of Avon once a year.
Right.
I mean, for a city, okay, you can get yourself together and hook together three city council meetings and you're done, no problem. But town, that could be really bad in terms of timing. So they allow the moratorium to say, okay, this is going to allow the town to instead of put something slapdash together to address a potential problem, to say, how do we want to unfold comprehensive zoning bylaws to address the permitting of medical marijuana and recreational marijuana, which all makes sense, but there's a limit to those, right? Once the moratorium expires, it's done.
And she told us right out, there's no way you're not gonna zone it somewhere in your town.
Yeah. Yeah.
So, I mean,
Yep. Yeah.
And again, just because we have the public listening too, so the reality is, we cannot zone out medical marijuana.
Right.
And this town has, designated an area in town
Yeah.
that it's acceptable or permitted, I guess is a more proper word than acceptable.
Yep.
Right, and even though there might be some people in this town who say it's bad and we shouldn't have it at all, but from a legal standpoint, we have to entertain it to at least listen to it, and we can't deny it just because we don't like it.
Right. From a zoning perspective, you can't say this is prohibited. There is a lot of discretion in an HCA, right? And that's actually been recently discussed at the SJC, is their discretion. And there is discretion. And what do you look at? Are these guys going to be good partners for us? Are these guys fly by night businesses that are just looking to set something up and then sell it? Are, do they have the same corporate principles that we are interested in? All of those things are important factors for you to consider, because I've seen big companies come in and do a presentation with their PowerPoint and they're sophisticated and you feel confident. And I've had other people that have virtually no plan.
Circuit dudes.
Yeah. And then I've had everything in between. So, it's really important to ensure that they're trustworthy and you feel confident that they're going to establish a business that's reputable, that they're going to work with your police chief and fire chief, that they're going to work with the town to be a good partner, and that they're not going to fold and then you have an empty storefront,
and the
right?
money.
Because that's what you don't need. You need that like a hole in the head. So those are all really important questions that you kind of have to delve in on an individual basis.
Are we allowed to look at their business pro forma?
Yeah. You can ask them, there may be certain things that they would want to protect for, so one company told me, and I was really surprised because it was like, what did he say? It was something so specific. It was like, if they know exactly how many pounds of marijuana we're going to generate at this facility, they'll know my cultivation process or something like that. And I was like, how would they know that? Don't you just water it? But they're much more sophisticated than I am. And so they didn't want to disclose something like that, but they would disclose their business plan, their financials, their perspective, gross revenue, all that kind of stuff. But on the cultivation side, it's super secretive. It's like your grandmother's sauce, like don't ask.
Wasn't there something recently, say the past couple of weeks, where I'm not sure if I have it exactly right, but there was a company that didn't disclose that they had pieces of other companies or other licenses or something?
Oh, I don't know. I don't know about that, but I'll tell you what I'll guess at what the problem is. There's a limit at the CCC as to the number of licenses you can have, and you can have 3. And some companies, I imagine, are pretty crafty and they have financial backers and silent partners and whatever. And what they don't want to have happen, right? Because the whole unveiling of recreational marijuana is to really raise up the disproportionately impacted, right? That was the genesis of this whole thing. And so they don't want a mega Amazon to corner the market on the entire industry, because it's supposed to be for to encourage smaller companies that are coming from communities where there was undue enforcement of criminalization of marijuana, et cetera. Or the negative impacts of the drug war in all respects, violence and all that stuff. So it could have been something like that if you are not disclosing fully who these silent partners are, or people who aren't actively the face of the company. That's a huge issue, because all of that has to be listed because they want to track them.
Is that 3 recreation and 3 medical, or is it just 3 licenses in general?
A corporate entity.
Yeah,
I think the 3 license limit is actually on the recreational side, but I'm imagining that's what you must have read. I don't know if there's a limitation on the medical side.
that was a big thing usually with convenience store, liquor stores, where you could only have 3, and it would be everyone's cousin owned 3, and the other cousin owned 3.
Yes.
The other company owned 3.
Well, that's a franchising now.
Yeah,
mentality.
you'd have,
You buy one franchise license, you open 10 stores. You know what I mean?
it was just one family who owned it,
Yeah.
they would have 10 of them.
Yeah,
Which would be one.
Because that's what they're probably trying to squash.
Yeah,
Is going into a because this is the perfect type of business that franchising could be huge down,
for sure.
right next to every Dunkin' Donuts.
And we have seen, you know what, going back to your question, I'll tell you one of the changes that I've seen happen, and your question was more enforcement related. But I have seen a significant amount, I don't want to say significant, I was trying to see how many, on at least 5 occasions where businesses were bought out. So they go through the leasing, the CCC licensing process, and then they sell it to another company. And you're like, hey, I thought this was a 5-person outfit and they all,
They
came
don't
from.
build on the money.
Yeah, exactly. They all came from Brockton. We knew those guys, and then they bring in, I don't know, the suits, and some of my communities wanted to have smaller businesses. Others wanted the big businesses because they felt like it was more secure, but depending upon your preference, and they switched it. So, but that process did have to be approved because you need approval of the, in the agreements I write, you need approval of the contracting authority to assign your HCA. So I have seen that happen. I don't think anyone perceived it as being negative, but I have noticed.
Okay, what if it's assigned prior to the signing of the HCA?
Well, if you haven't signed the HCA, you wouldn't be assigning it, you would just be executing a new contract because, right, if you don't have a signed contract, there's nothing to assign.
Can't stop the process, right?
But no, you would have to just negotiate with you guys. So if, for example, Corporation ABC said, I want to enter an HCA with you and you're in the process of negotiating and you don't have a signed agreement, and they say, well, we're going to sell to XYZ company, then you say, well, get XYZ in here and negotiate with us because you've got nothing to assign until that thing is signed.
Yes, sir.
I just had one question before, if everyone's done, was like, you talked about recreation and delivery. You're not allowed to deliver in a town that is not allowed recreation marijuana, correct?
Yeah, so that's right. So the way delivery works is if
Just to
you,
piggyback on before we go to the
Okay, go ahead.
medical, can you deliver medical
yep,
through that
Is it
process?
considered a
Is it
medical
the same
supply?
type thing? versus recreation?
delivery of medical is allowed. That's not considered separate.
That's any business in the Commonwealth who has a medical marijuana license can sell or deliver medical marijuana to any person in the Commonwealth.
Yeah. So on the recreational side, which is the side that people more care about because you can have your what's a bad opioid, Oxycontin delivered to your door, I think, right? By CVS.
Yeah,
I think you
actually,
can.
you can have that card.
Yeah, you can get narcotics, you can get your whatever pills on delivery. So on the medical side, they're less concerned about it. They're really concerned about it, or what I've seen is residents be very concerned about the recreational marijuana because the risk is, I've got a fake ID or whatever I ordered, just like I went down to the package store when I was 18 and got with my fake ID. So not me personally.
Okay, for that.
My mother's in the shower, just she'll be right down, just give it to me, I'll be okay. Right.
Well, isn't it possible, and I
So-
know this is kind of like a real strange type of thing, but and I'm only saying this because by accident, I went to visit another business in part of his building, he leased out to a delivery service of marijuana. And they have no inventory, no nothing. They pick it up that morning, they deliver it, that type of thing. But, getting to where you were talking about, you didn't want the Amazons of the world.
Yeah,
Isn't it possible? Maybe I should go in this business. Is that if you create a fantastic delivery, as long as you could buy it and get it delivered within whatever parameters you say, if we're gonna be the Domino's of delivery, you technically don't have to buy it from the one that's in Avon. If you're, you could buy it I'm saying, and I don't know who physically buys it, but
Yeah.
you could pick it up at locations that convenient for delivery and then, you know, drive it wherever you want it to go to.
Yeah, so delivery is a concern for retailers, right? Because just that convenience factor, right? I never used Amazon as much as I do now, and I'll tell you the number of packages I get, and it ranges from
You're
dog
not gonna
food.
stop either, are you?
No, and it ranges from dog food to, I had to get kids sneakers, because when I went to the brick and mortar store, they didn't have sneakers. I digress, but in any event, so the retailers are certainly concerned that that could kind of curb their customer base, right? But the difference is there are so many communities in the Commonwealth that prohibited marijuana, that delivery isn't allowed for those folks in their towns. So if you're like Avon and recreational marijuana is not allowed, you're not allowed to get delivery unless the Board of Selectmen
Of recreational marijuana.
of recreational,
Okay.
yeah.
But you are allowed
Yeah,
to get delivery of medical
you
marijuana.
can get the
And it
medical.
doesn't have to come from facility, if there's one located in this town, it doesn't have to come from that facility.
That's true, it could come from elsewhere.
But could we have
So-
something in the HCA that, or through the permitting or licensing or somewhere within the town, that the company coming into town would have to provide their own delivery? They couldn't use a third party? Is that something we could, like,
Well,
they would have to employ their own people to do the delivery rather than having a third, like you have Uber, you have Lyft, you could have highway.
But-
Right.
You know, I
but
mean,
Before you go, but take that one step further. The guy down the street that's over the town line, he can deliver to us and we don't have any control over that. That's what you want to control.
true,
You don't want to control it as much. You don't want to control the guy.
but that would
that's
still
here.
only be medical to medical.
Yeah, and that's all we're talking about,
Right.
just medical.
Okay.
so there's a difference. I'm pretty confident so on the recreational side, this is how delivery works. There are two types of delivery services. One is the courier, which is what you were describing, which is the DoorDash. Like I don't have any product in my facility. I just go to the retailer, pick up the marijuana and deliver it to the house of Jane Doe. And that courier never purchases the marijuana. Instead, they just charge a delivery fee.
Right.
So the other type, which is the more attractive type and the type that I think people are trying to get into, because the profit is much more significant, because think of all the deliveries that you have to do for, I don't know how much a delivery service fee for marijuana would be, say, is it $2? Is it $10? I don't know, but that's not a huge amount when you're paying for gas and cars and all that stuff.
But people are making money doing DoorDash though,
Yeah,
and that's gonna be potentially lower delivery fee
Most of
than
those,
marijuana.
most of the orders for DoorDash, they build in anywhere from a $7 to $10 tip on top of what you might give them. So,
yeah.
you know, and they're generally within a 2 or 3 mile radius, so.
So it might be worth it, but where the real money is, I think from my perspective, is the other license, and it's called the delivery operator's license. And what those guys do is they go to either the cultivator, the manufacturer, or the retailer, purchase the marijuana and say it's called Jason marijuana at this place. They take it back to their facility and they call it Steven marijuana. They package it up and they sell it as their own. And then they make whatever profit there is, the delta between what they purchased it for and what they sell it for. So, and that's the one that's currently rolling out. And there's a potential for big profit there, I think. Because they don't have all the costs of creating that marijuana and growing it and then forming it into the chocolates or whatever.
And I'm sure that the grower, if he gets, just like in anything, if he can wholesale it out versus retail it out, and
Yeah.
he's got a great delivery.
The grower
Service.
wants to sell it to anyone.
Right?
As long as they're making the money downstream, everybody's happy.
Exactly, so, but the thing that's concerning, the retailers wouldn't care if they could just snap up another license. but most of them aren't social equity or economic empowerment applicants, and those licenses are given to them, to those candidates for the time being. So that's where the CCC said, okay, listen, we've realized that the folks that tend to be in this industry are not the ones that were targeted by the legislation to raise up. And instead it's being diverted to the same old people who make a lot of money regardless. So we want to make these licenses exclusive to the economic and social equity applicants. So that's why the retailers are feeling the pinch, because they can't, many of them don't meet the qualifications to satisfy their licensure requirement for that.
I think the main part of that was
I think
just
I
to
went
bring
off
up,
topic.
to make sure that people are aware that, even if you guys agree, go into an HCA for medical, that recreational deliveries are still not allowed. Now, we had a company who did come in before and ask us if they could potentially be a delivery service in the town of Avon, and they were looking to get into the business. Because we have our bylaw written that way and how it's voted, we told them they couldn't have it,
Yeah.
but just so it's not.
Yeah, a lot of the communities really like the idea of the delivery operator. So I have one community that was no to retail, but yes to the passive uses, so the cultivation, manufacture, et cetera, because they were interested in economic development, but they were hesitant to invite retail because of their impression of what the negative impacts would be, foot traffic, or maybe the customer base isn't what they wanted to attract to the town. All of those things that people were struggling with in the beginning. So they went passive use, no retail. And now they're looking to open it up to delivery because you don't have the same kind of foot traffic, but you have the generator of money because you're getting their retail sales tax along with the community impact fee payment.
Other question here.
Sorry.
I'm not sure if you'll answer it or not, but the recreation, it doesn't really pertain to us anyway, so I really don't, it doesn't mean anything.
Yeah.
It's that's basic. It's as long as you're 21, you can get delivered to you as long as it's allowed tax. So
Yeah.
this specifically is for medical for us.
Yep.
How is it possible to deliver medical marijuana? The reason why I ask is every presentation we've received or anybody we've talked to that is trying to promote this to the town of Avon has said to us, you need a medical card and a valid ID to get into the store.
Yeah.
You need that same medical card and a valid ID to talk to somebody, and then you need the same medical card and a valid ID to pay for your product.
Yeah.
So if it's Fort Knox to go to Main Street in Avon
Yeah.
to get something for your cancer pain, how is it even remotely possible to deliver medical marijuana anywhere, let alone just Avon?
So I think what happens is you get like a pre-approved profile type thing where all of that security stuff is vetted.
Like a background check?
So what?
Like a background check?
No, not like a background check, but here's my license, here's my medical card, here's my face, and this is who I am.
I'm incapacitated, I cannot go pick up my medication.
Yeah, exactly. So I'm pretty confident that's how it works. I actually, and none of the HCA's that I've negotiated have involved that component, but I know that from a medical marijuana purveyor. But I'm pretty sure it's like pre-vetted, like almost like, that thing you get for TSA pre-check.
Yeah.
So you've done all that work in advance, so you can go on the shorter line at security. So I'm pretty confident that's how it works.
So is it possible to put in the HCA that, or is the CCC kind of wrote us down? Is it possible to put into the HCA to say, you can have walk-ins, but we do not want you to, I mean,
Yeah,
the presentations we received, they said they don't do that anyways, but if a year into it, they're like, geez, we're really losing money here. We
Yeah.
could definitely use the delivery service. Next thing you know, you got 47 little black vans pulling out of this parking lot every morning.
so yes, the answer to that is yes. no delivery can be added into the agreement. And so, for example, I have one community that allowed medical, but only what they wanted to see in their HCA's, what it was that it was only going to be the passive uses, so the cultivation and manufacturing. They do the same on the recreational side too, only manufacturing, cultivation. But so in their HCA's for medical, it specifically says there's no dispensary here. This is just to grow. This is what we're agreeing to. And that was important because when medical was first rolled out, you had to be vertically integrated, meaning you grew that marijuana, you manufactured that marijuana into product, and then you sold the product, and it all had to be through the same company. But these companies, they did it in all different locations, right? Because you don't do all the same thing in the same house. So you might have your cultivation facility that's Corporation ABC here, and your dispensary in another town. And so those HCA's specifically said, this is allowable for medical marijuana treatment center is what they're called, even though if it's just a cultivation facility, it's still called medical marijuana treatment center for the purposes of cultivation only. So that's why I'm saying, yes, you can preclude delivery.
So I guess to add more confusion to his question,
Yeah,
so if we hypothetically don't allow the medical marijuana to be delivered from Harry, who's in front of us. If I'm, again, a cancer patient, and I did my profile, and I have a legitimate prescription from
Yes.
the doctor.
Yeah.
What's to stop me? I guess the question is, can I then, okay, I can't call the one in Avon to get delivery because delivery is not allowed from Harry's and Avon. I'm gonna call Sally's in Brockton, which is nearby, assuming Brockton allows delivery.
Yeah.
And I can have them deliver to me. Is that,
yeah.
that's
that
a
would-
possibility?
That's a possibility.
Right.
So by denying them the option of doing delivery at Avon does not deny people of Avon getting delivery from someplace else.
Exactly.
Right?
That's right.
Can we legally, if the medical marijuana rules are a little different than all the other recreational rules, do you see somebody challenging not allowing delivery of medical marijuana? Because as an extension, medical is medical. The obtaining of that product, if you can't deny a medical marijuana retail outlet, can you legally deny a medical marijuana delivery
Well,
coming out of that same?
remember, zoning is different than your right to contract, right? And so the case that went up to the SJC, this was the situation. There was a company, Mediri, and they were, I think it was Salem, put out an RFP for, and this is the recreational side, but the concept's still the same. They put out an RFP for marijuana retailers. I think marijuana retailers, or I don't know what kind of marijuana establishments they were, but let's say they put out and they said, we've got six licenses that we want to issue. And welcome anyone and come and present to us, and we're going to take whoever we think are the top 6 candidates. And they chose them, and Mediri wasn't among the top 6. So they sued, and what they said was, hey, we met all the standards that were set out in the RFP. We complied with everything. They didn't have a right to choose, not us. And the city said, hey, we have the right to contract with whomever we want. It's our choice. And it could be based on, so some of them were like, I think they were trying to spread them out through the city and do all kinds of other things, you know? So they had some legitimate reasons for not selecting them. And maybe it had to do with experience or whatever kind of like fungible stuff. And they won in Superior Court. Well, the argument is sound because contracting authority, put procurement aside for a second because we know the hiccups with that, right? But contracting authority, what the court said is that no one can force you to contract. And you have the right to choose who you want to choose to work with. Just like if I'm hiring a contractor to put an addition on my house, I can choose who I want to work with, and it could be the best guy or it could be the worst guy. You know, it's up to me. And that's an inherent executive function vested with the Board of Selectmen. So I think zoning is what you're talking about. And you're right, you probably wouldn't be able to prohibit that in zoning. But contracting is different when two parties are saying, hey, this is what we're going to tolerate. And the other side said, oh, I'll tolerate that condition. Then it works for both parties, and we presume everyone's hunky-dory. We went in eyes wide open, both had counsel. Done.
Any other questions?
I think.
Administrator, town council?
Mr. Chairman, I've had long conversations with Kate.
Yes.
I feel sorry.
Give you a couple extra hours of that.
I know. Only a couple.
Hazardous duty day.
Is there anybody on or?
There's not.
Who's the one participating? Is that you?
Us.
Okay, so we don't have any questions from, do you have any questions? I'm sorry, I didn't want
Questions.
to, no? You sure?
I'm positive.
He just wants to know when they,
You
do
get
we
delivery at your house?
do we put in the HCA about regular samples for testing purposes?
What's that?
Do we put in the HCA about regular samples for testing? Just for testing, I'm sure.
It would be deducted from the 3%.
Yeah, exactly. I wonder if anybody's ever done it. Has anybody ever donated product to like a senior or to somebody that needed it in town? Would that fall under the 3%? I would assume it would.
I don't know. I don't know if that's allowed.
I'm just curious. I mean, if somebody
It's a
does have.
convenience store giving out a pack
Well,
of
it's-
cigarettes. It's probably against
No,
the
but
law.
if somebody has a prescription and has all the proper
Yeah,
information, they know this person is there. Could they donate that kind of product?
that would be great. Or if they
Somebody
had
was-
like some sort of subsidy, like, you know, if you have,
I'm not saying I
This
want them to do it. I'm just curious,
income
if they could do it. to knock it off
Especially
right down the
for
road.
unemployed selectmen.
If you're on Medicare, it's 70%.
Oh, that was hot. Wow.
All right, so what's our next step? Now that we got educated, we kind of
Yeah.
know the ins and outs a little bit of some of the things that we can talk about. when
Yeah.
We get to certainly negotiating and so forth. So
Yeah.
we have the general information now.
Yep,
So we have an applicant
yes,
that is, wants to move down the road.
yep.
So what's our next steps without giving away the house here?
So,
First is to pay her bill in a timely manner, which then speaks to us again.
I know where to find you, so.
Yeah.
So the next step would be, working together. I actually think some of the things you raised as general questions might be really helpful to incorporate into this agreement that may have been otherwise not included. So work some of those things into the agreement, work with their counsel, see if it is acceptable to them, drafting that up and presenting it to you at a meeting where we can walk through the agreement, talk about what the provisions mean, whether or not there are other issues that you want included or things you want omitted. And then the question is, do you feel, I mean, you had the presentation from them about what their business is.
But we haven't seen the pro forma yet. so-
No, you can request documents in the meantime.
And then what about any comments or anything from the public outreach? So they had that meeting,
We had a
right?
meeting, we asked people any questions,
Who's
email us.
who's we, out of the
We were at the meeting where we said, anyone who has any questions, email.
public
info.
outreach meeting?
Yeah. Yep, email info@, you've only got one submittal so far.
Okay,
How many people showed up to the actual meeting?
It was mostly town employees. Oh, you mean the one that they had?
The one
Right,
they-
yeah, I'm talking about the one we had.
No, the public
no.
hearing.
Oh, no, that one I don't know. I
Public
think
hearing.
they said they had about, I think Kathleen said there was about 8 people there.
and was that recorded so that we could?
Yeah.
Yeah. It's recorded, I believe.
Yeah,
Yeah,
Public-
so that-
Gary had, I think Gary was
So
there.
we should look
That's
at
on
that
the-
and see what comments was from the general public or what they talked about to make sure you're looking at me funny on that.
No, we're getting one more comment for today.
Well, that's okay. We can get comments till
Up until-
the moon comes.
Okay.
And we do have, the Board of Health did say that they were gonna submit a statement. I don't think,
That's the comment I'm thinking of. Yeah, with the
Yeah.
prevention coordinator
yeah,
and supposedly a couple of students
yeah,
from the, yeah, Avon
that's part
Middle
of
School.
it. So they're, I know they're drafting it out.
So before we, I'm throwing this out as a trial balloon. Before we do anything else, I think we should get a copy of the tape for their outreach.
Yep.
And get all the comments. And any kind of conditions that we talked about tonight,
Mhm.
is we probably should get all that stuff organized before we do anything else, because I don't want to start negotiating with them and then say, oh, we forgot to add this or whatever. I'd like not to do that if possible.
Sure,
But certainly, try to move the process along so that if we're going to get to an ACA or not get to it, that we make that decision.
understood. Yep, so,
Now, Chuck, I think we might have I thought Gary was gonna give us the link to it.
Okay.
To see if it's on the
I'm
website.
just saying, someone should look at it in case there was someone in the audience that had something that we didn't talk about tonight that's important to at least explore.
yep,
And then we can certainly take the comments from tonight, get them organized, and then create some bullet points or something, and
If we're gonna,
councils can exchange pleasantries and say, this is where we're headed, that's where they're headed, and see if there could be some kind of compromise
yep.
or not.
What I would do is even more formal than bullet points, because I
Okay.
have, I would give a proposal.
So right now, I'm just worried that if you give a proposal, which I know you're
Having
doing,
done.
is
after
make sure that
doing-
we have everything
Yeah,
so that there's, we all forget, oh, I should have added that. I don't want to do that, especially because I don't know how important it will be, obviously, because this is our first one.
understood. No, I
So this
think,
is very precedent.
yeah, for sure. I think everyone understands that, this isn't like union negotiations where once you present it, the horse is out of the barn and you can't walk it back in. But if we can take care of the bulk of it and present to the entire body a document that's pretty close to where you would want to be, subject to some tweaks here and there where there are individual preferences. I think that's probably the better approach than trying to hash out the whole thing as a group, because a lot of the stuff is important, but mostly agreeable to all sides. Just like most other contracts, you have the 50-page contract and there are 2 pages that you pay attention to. So, so that probably would be the best, and then to say, okay, here's where we have to fine tune it to meet my needs, and you want my vote, so that kind of thing. If that makes sense, does that work?
Mhm.
Okay,
One question on that, is in terms of process and procedure, would it be or make more sense to have the board vote at some hearing in the future, meeting in the future to say they would be willing to enter into the HCA? And then have a vote of a final thing when they have the HCA? In terms of like timing, in terms of the developer who wants to know, because right now there's no vote either way,
yeah,
and would they want to?
From a personal standpoint, just
I'm not-
because, no, I'm just saying, but from a personal standpoint, I don't think I want to let my horse out of the barn yet, because just in case, I think we had a good conversation tonight.
Yeah.
You certainly, learned some things that, by our questions of what, I don't want to say necessarily concerns, but things that we have thought about.
Sure.
And without understanding what, the applicant is, the applicant could say, I don't agree with that. And I don't know if I want to tell him right now that I'm willing to vote yes or no, with that.
Yeah.
So I think I want to be further down the road
Yeah.
to see if, we can, if we're going to vote positive for HCA, that it's a good compromise for both parties.
Yeah.
Not just, this is what they want, and we have to say yes or no.
I was
That's just my personal.
No, and I was just only thinking because if, say, like you said, we could still ask them for the pro forma stuff prior to that and get all the information without it being part of the HCA. It's just whether or not they want us to tell them, which way you're leaning, which we, like you said, it's up to the board to figure out how they want to handle that, that's all.
I mean, the board, obviously, the members can speak what they want to do and so forth. I'm just saying from my personal perspective is that because this is the first one for the town, this is precedent setting. And other than the propaganda that they gave us in the presentation, and I'll tell you that's what it is, we didn't really ask very many detailed questions.
Yeah.
I think that we should be afforded the opportunity to ask some very detailed questions and make sure that the answers are in the realm that's acceptable to us.
Yeah.
That's just my personal.
Do we know of any time constraints that they're under? Or are they looking for? Do they have something? I mean, I know probably as soon as possible, but I mean, is there any kind of high dates that they have in place as far as leasing or?
I
know,
don't
what they're
think so.
looking
I
for?
know that their representative, so to speak, has been in town hall looking at the permitting process for the building. So I'm sure they're trying to get all their ducks in a row.
To do what fitted out, you mean?
So I'm sure they're trying to get everything, ducks in a row as well. So that if and when there is a decision one way or the other, they have all the information in the end about what it's gonna cost them permitting wise to get that stuff taken care of. But they know that there was a comment period that we had after our hearing. And then they had their own hearing, so they know that there's a timeline. And I'm sure they're looking to, like you say, get it sooner rather than later.
Other comment, anything about that? No, you?
All right.
Thank you for coming in, appreciate it.
Thank you so much for having me.
Thank you.
All right.
Very educational.
Oh, thanks.
And let's hope that tomorrow there's not a, case law that's gonna throw out everything.
Yeah, forget it. I'll just write to you. Forget it.
Yeah.
Whatever it's,
In the whole area. Because I think close enough, don't we?
You more than me.
Depends on if the wind.
I'm down at the bottom, so the wind blows, they go to you.
Thanks. Have a
Thank you
great
very
night.
much.
Thanks.
Thank you. Do we have anything else?
Nope.
Okay, we'll take a motion to adjourn if we're gonna do this officially.
Motion to adjourn.
Second, motion to adjourn, yeah. Thank you.